last part of Jackson's 2 terms as president for us to address is his policy concerning Native Americans, and it's really twofold. We have the Indian Removal Act of 1830 and the subsequent removal efforts, often termed as part of the Trail of Tears. To understand the policy, we need to look at the context of what led up to it. Now recall that conflict between settlers and natives had existed since the first English came ashore at Jamestown. The Pequot War and King Philip's War, both of which were fought for the purpose of gaining land, really decimated the native populations of the East Coast. And they were particularly brutal because they often pitted native tribes against one another. King Philip's War in particular ended widespread resistance to European settlement on the Atlantic coast. Coming at the end of the French and Indian War, Pontiac's Rebellion was a series of revolts in which native warriors in what's now the Midwest attacked frontier settlements. Now, Chief Pontiac of the Ottawa Nation was the most well-known, so it was called Pontiac's Rebellion. Now, to simplify, the attacks occurred because settlers began to trickle onto land that belonged to native tribes, and it results in King George III's proclamation of 1763. This episode illustrated that white settlers were about to start settling west in droves, and they were not really going to show much respect to the land rights of Native Americans. Under the Articles of Confederation, it's 1786, Henry Knox is Secretary of War, the government takes a different policy, and Knox believed that the concept of right of conquest was wrong, and he believed that the federal government did not have the resources to fight countless wars in the West. He believed that lands should be purchased, they should be bought, and that would be less expensive than conquest, and natives should subsequently be instructed in the economic ways of white settlers so they'd be more, quote, willing to part with their traditional ways and traditional lands. Now, in theory, that's one thing, but settlers ignored native rights to the soil. And the Battle of Fallen Timbers was followed up with the subsequent Treaty of Greenville, which ended widespread resistance to American settlement in the Northwest Territory. So we're seeing this push, we're seeing this pattern of ending resistance, first on the East Coast, now in the Northwest or the Midwest. And as the 1800s began, the U.S. Army fought with natives on multiple occasions. Jackson himself was involved in several of these, as he took on the Creek in the Creek Wars. He was involved in the War of 1812, although he personally never fought the Shawnee-Tecumseh, and he invaded Florida to fight the Seminole Nation. It's pretty clear that east of the Mississippi, conflict is going to be a continual occurrence between settlers and thereby the federal government and native tribes unless something is done. Now, at first, that something comes in the form of the Supreme Court and a series of decisions that have become known as the Marshall Trilogy. Recall that John Marshall is the 4th Chief Justice of the Supreme Court, and he really helped establish a series of revolutionary precedents, like judicial review with Marbury v. Madison, and the Necessary and Proper Clause with McCulloch v. Maryland. This trio of decisions that took place over the span of a decade will help establish some long-held precedents for the relationship between the federal government and native tribes, and they in fact still hold today. In 1823, the court issued a decision known as Johnson versus McIntosh, and Thomas Johnson was one of the first Supreme Court justices. This guy had bought land from natives back in the 1770s, and his heirs were disputing a claim to the same land made by a man named William McIntosh. The suit was dismissed on the grounds that the land did not actually belong to the natives, as it had belonged to the Europeans using a legal doctrine known as right to discovery. Therefore, any land that they wanted to sell technically belonged to the United States, and they needed government permission to sell their land. So that's step 1 in the trilogy. Now, step 2, 1831, Cherokee Nation versus Georgia. The Attorney General for President Monroe and President John Quincy Adams was representing the Cherokee Nation of Georgia, and their lands were entirely contained within those states' boundaries. By most markers of the time, the Cherokee had been considered what was called civilized. All right, they'd taken up settled agriculture, they opened schools on their lands, they published a newspaper, and they even had a written alphabet for their language. They were taking the state of Georgia to court because they claimed that Georgia was unfairly trying to assert Georgia state law over them, thus violating decades of legally binding treaties. Now, in a majority opinion, Marshall actually declared that the Supreme Court was not allowed to render a decision because even though the Cherokee had filed a lawsuit as a foreign nation, he described them as domestic dependent guardians, meaning that the relationship between the federal government and Native Americans was like a parent to child or a ward to his guardian. The federal government has always treated Native tribes as sovereign nations, and this really seemed to go against that. Now, Marshall did state that the court might rule under different circumstances, but bear in mind, this is a year after the Indian Removal Act, so he's not necessarily going to challenge Jackson directly on the issue. Now, that issue comes up the following year, 1832. The Cherokee are in court. 2 Christian missionaries had been arrested on Cherokee lands after the state of Georgia had passed laws preventing whites from living on these lands. The missionaries were convicted and sentenced to 4 years of hard labor. One of them is a guy named Samuel Worcester, and he appealed the state decision to the Supreme Court. Marshall ruled in favor of the missionaries and the Cherokee, and he stated that the tribes were distinct communities who had their own laws that were not subject to the states in which they bordered. While dining, Andrew Jackson was reported to have heard of the decision, and he said, "Well, John Marshall has made his decision. Now let him enforce it." And this remains one of the few times in American history when a president outright refused to honor the decision of the Supreme Court. So this explains how relations with Native Americans are going through the court system. Now, Andrew Jackson 100% believed in removing all natives to lands west of the Mississippi River. He claimed it was mainly for their survival of their way of life. And there may be some truth for this, but he also wanted the land for settlement by white American settlers. Eventually, Congress was to approve the Indian Removal Act, but there had been talk that Jackson was abusing his power and forcing people to leave their traditional lands. The 5 what were called civilized tribes, that was the phrase at the time, they were the ones that were targeted the most. You have the Cherokee, Choctaw, Chickasaw, Creek, and Seminole. The first to be removed were the Chickasaw. A meeting of the chiefs of the 4 C's was called, but only the Chickasaw made it to Tennessee for the meeting. Now that deal eventually fell apart, but Jackson's men eventually found people who were willing to deal. The Choctaw are going to go first because winter of 1831, they are removed. There was a Choctaw who claimed, "Our doom is sealed. There is no other course for us but to turn our faces to our new homes toward the setting sun." And French writer Alexis de Tocqueville, who was recording his impressions of the United States at the time, he recorded the struggle of the Choctaw. And this struggle will be repeated time and time again. But it sets this precedent of federal agents finding members of these nations willing to give them what they want and sign on the dotted line. Now there certainly was resistance to removal. The Sauk leader Black Hawk fought back. His people, along with the Fox, had been forcibly removed from Illinois across the Mississippi River, and they had returned to hunt in their former lands only to find that white squatters had settled in. Now they fought with the settlers, and the Illinois militia, along with federal troops, chased them into what's now Wisconsin and annihilated them at the Battle of Bad Axe. Hundreds, including women and children, were killed, and many drowned trying to escape across the Mississippi River. This massacre demonstrated the lengths to which the federal government would go to enforce removal and keep natives west of the Mississippi. Now, the Cherokee often get the most press, so to speak. Cherokee removal often makes its way into textbooks, and for good reason. The Cherokee continue this model of finding members willing to deal, and the Cherokee had signed a removal treaty, known as the Treaty of New Echota, but it just wasn't representative of most of the Cherokee Nation. John Ross, Chief John Ross, was the leader of the National Party, and he represented about 16,000 of the 17,000 Cherokee who did not want removal. The Treaty of New Echota was signed by Major Ridge of the Treaty Party, and Major Ridge simply believed that removal was the only hope the Cherokee had to survive. Jackson's administration chose to accept Major Ridge's faction, and the treaty was ratified in the Senate, but by one vote only. So the deadline for removal is set for 1838, the year after Jackson left the White House. Now, for his role in the treaty, Major Ridge and his son were executed on the new Cherokee lands in Oklahoma once the movement was complete. Now, when this deadline comes, the vast majority of Cherokee, they were still in their lands. They hadn't left. So the military showed up, and they removed them at the point of a bayonet. The military forcibly removed this society, this civilization. About a quarter. 4,000 of the 16,000 Cherokees died along what became known as the Trail of Tears. And there was one Georgia volunteer who would become a Civil War veteran who claimed that the Cherokee removal was the cruelest work I ever knew. Now, Jackson was out of office, but the policy was his legacy. He had claimed that removal would be just and humane, but it certainly wasn't. He really did believe that native tribes and nations would be saved, and they'd be out of harm's way with this policy. So looking at his legacy when it comes to removal, as well as the whole Marshall Trilogy, that's one lasting effect of Jackson's 2 terms as 7th President of the United States.